Good afternoon, and many thanks for the invitation today from Together Scotland. My name is Joe McGinty and I work within CELCIS, Protecting Children Consultant. My background is in social work and local authority social work, so very much embedded within child protection practice. And I want to speak today about how the UNCRC and children's rights and the articles have greatly influenced child protection practice and policy and legislation within Scotland. I want to explore how children's rights have shaped child protection practice in Scotland. Also talk about the complexity of the child protection task and how the rights-based focus can continue to support improvements. I want to focus as well on voice and participation, which has been, a big emphasis in the last few years, quite rightly, and it goes right back to the 1995 Act in Scotland in terms of the views of the child being very much one of the overarching principles, but that was directly shaped by the UNCRC Article 12. That's just one example of how UNCRC has shaped legislation within Scotland. So this slide is really just to illustrate that the UNCRC has now been well established internationally. It's been around since 1989. It was ratified in the UK in 1991. I think it's become fully established within the UK, although it's now we're looking to incorporate it specifically into Scots law in the next year. There's been some delays with that, as people are probably aware of, but it's hoped that that will be very much established by 2023 and give an important kind of impetus to a rights-based agenda within Scotland and the Scottish legislation. So the articles establish what all children need, which, if we think about it, sounds quite like what GIRFEC's trying to establish within Scotland as well, looking at children's needs. So again, we can see how UNCRC has influenced practice and policy within Scotland. So the basic right to be protected is supported by other articles, and the basic right is Article 19. In this sense, the articles interrelate and they mutually support each other with the overall aim of establishing the rights of all children. As I said, it's hopefully been incorporated within Scots law, and that should be fully established by 2023. I'll go on to talk a bit more about some of the other articles and how they have directly influenced child protection practice. I want to start up with GIRFEC, which is very much a kind of flagship policy, the broad policy that covers children's needs within Scotland, and child protection falls within that and is very much incorporated within the GIRFEC policy. So GIRFEC is the key Scottish government policy premised on the same aspiration of the UNCRC, that all children have the right to grow up and be safe, nurtured and loved and their needs met. However, it recognises that at times some children may need extra support and that they should get this at the earliest opportunity, and that the processes and supports to families should be clear and focused on what the family needs, with the child very much at the centre. GIRFEC has undergone a recent refresh, and what we can see here is some of the kind of key parts of the GIRFEC policy. The My World Triangle, very much the child at the centre, which helps the workers and practitioners working with families assess a child's needs and think about the risks that might be around for a child. And also the resilience matrix is illustrated there, which again helps workers think about what are the key factors in the child's life that are promoting resilience, which we'd obviously very much wish to promote for children in Scotland. Just to say that again, the UNCRC rights are very much reflected in that My World Triangle and the scenario indicators: safe, healthy, nurtured, etc. UNCRC and child protection. Now, the graphic on the right is the new national guidance for child protection in Scotland, and the UNCRC has directly influenced legislation and policy over the last 25-30 years within Scotland, going right back to what I remember in my early career in social work was the Children's Scotland Act in 1995, which talked about the overarching principles of the best interest of the child, which is obviously Article 3, the views of the child being taken on board in any major decisions relating to children, which is Article 12, and also minimum intervention, which I think is reflected in the kind of parts of the articles that talk about, that a child should remain at home with a family, and the state should only intervene if absolutely necessary to keep that child safe. And they should also offer supports to families to make sure that they can meet the needs of their children, which are reflected in some of the key articles within the UNCRC as well. And within the 1995 Act, that was Section 22, which is a well-established piece of social work legislation still used to this day. Process and rights. So I want to talk a wee bit about moving on from GIRFEC, where we know that GIRFEC is there to support children and families who need that additional support, but sometimes that support by itself may not be enough, and a more involved participation from a child protection process or a legal process may be required. So I want to take through the kind of main steps in the kind of child protection process, which are illustrated here on the left, and try and link it a wee bit to the UNCRC articles. So, as we know, if a disclosure or concern comes into social work department or police from a child from whatever source, the local authority and the police have got a kind of key duty to investigate that. Now we move from that kind of disclosure and concern, and the important part there is that whoever's received that disclosure from a child, whoever it may be, whether it's someone working in a school or whatever, needs to kind of very much listen to the child and hear what the child's saying and can record those concerns and pass it on. So it's kind of important bits about the views of the child there and making sure that the views are respected and listened to. And it's very much about respecting the rights and needs for that child to be protected and taking the appropriate action to make sure that happens, which is embodied in Article 19. At the next stage involves the part of the process interagency referral discussion, where police, social work and health really get around the table, and it's usually virtually, to discuss the case and decide what further action is required. Now, that process doesn't involve families directly, but the views of the child should be fed into that process by social work from the knowledge they have of the child, if they do have any, if the child is known to social work, or by the school or by the health records, and if there is any information on the police system about the child and the family, that should be fed into that process, and then decisions are taken about whether a child protection investigation should be launched, which moves us really into that kind of assessment and planning stage. So the assessment and planning stage should very much involve the family, and the child may require to be interviewed by a joint police social work interview, but again, it's very much about doing that in a kind of needs-led basis. Following the outcome of that investigation, it may be decided that a planning meeting under the new national guidance may need to be held, and the child may need to have their name placed on a child protection register. At any point during that process, circumstances can change, and the risk to the child may be perceived to have increased, and so emergency measures or a referral to the Scottish Children's Reporter may be required, and that's very much particular to the Scottish legislation. So the emergency measures are a child protection order under the Children's Hearing Scotland Act 2011. And again, within those legal measures, the views of the child should be taken on board, and the family, and the family should be informed fully of the decisions that have been taken. And again, the kind of minimum intervention principle comes in there, because we shouldn't be making those kind of emergency measures unless it's absolutely necessary, and we should be trying to reach a voluntary agreement and making other measures with wider family if we can do. So it's very much, again, centred on what is best for the child and the minimum intervention. So I think just from the previous slide, I've kind of tried to kind of emphasise that child protection practice is very much a careful balance between a number of needs, and the child's rights and needs, the child's views and wishes, the parents' views and the wishes of the parents and carers, and also taking into account the legislation and policy, thinking about the risks and the need for protection, and very much focused on that. So it can be helpful to think about it as that kind of balance. individual family rights, express views and wishes, and all the relevant policy and legislation that might apply. Now, doing all that is no easy task, and it's a challenge for practitioners involved in child protection. It's important, but start with the child at the centre and consider their fundamental rights and needs for protection, what they need for their development, and their wishes and views. And from that, consider if these rights are not being upheld or met, what protective action is maybe required, and develop an action plan from that. Sometimes rights can appear to clash or be in conflict, and this is where some of the balance needs to be made, often through the relationship-based work, which is kind of central to, or should be central to, social work practice. The rights are actually interrelated. So, for example, a child has the right to stay with their family, Article 9, if this is in their best interests, Article 3, i.e. if there is a need for safety and protection, nurture and development. If all these needs have been met, then there'll be no need for social work intervention, in fact. Another example might suggest a conflict or tension between different rights. A child's wishes and views, Article 12, expressed by them can sometimes appear contrary to what might be in their best interests, Article 3, especially if they're engaged in activities that could cause harm, Article 36. All of this needs to be balanced in the decision making, and the older a child or young person is, the more weight needs to be given to their views and express wishes. At times, child protection interventions and legal measures do interfere with rights. The most commonly cited might be the right to family life, Article 8 of ECHR, and there is provision for this in the UNCRC Article 3, the best interest of the child. So as can be seen, child protection rights operate in practice in a complex environment, and this is also reflected in the following slide when we consider the complex landscape of policy, guidance and legislation that operate within Scotland. Now, there's a few slides to follow here. I'm not going to cover them all in great detail, but they're really to illustrate the range of legislation that now applies within Scotland from a CP child protection context. The first slide here is really about offences against children, and some of these speak for themselves. And one that was very much driven by a rights-based agenda was Children Equal Protection from Assault Scotland Act 2019, which basically says that children should not be smacked by parents, and that is a form of assault, and they should be given equal protection that adults have in society from that abuse. Female Genital Mutilation Act 2020 is another recent piece of legislation, which again is covered within the UNCRC articles and also within the legislation within Scotland. Legislation on managing adults who pose a risk to children. These are very much focused on adult responsibilities and how services will manage risks posed by adults to children. Legislation, this slide illustrates some of the kind of overarching legislation that's come into being over the last 25, 30 years that covers child protection practice within Scotland. So, as we can see, it's very much a cluttered landscape, to borrow a phrase from the promise. So the range of relevant legislation, policy and guidance across safeguarding is complex and ever evolving. The above landscape is only the tip of the proverbial iceberg. It was the Independent Care Review and Promise Scotland who coined the phrase a cluttered landscape to illustrate the complexity and confusion this often brings to both practitioners and, more crucially, to children, young people and their families. The legislation and policies are aimed at improving how we safeguard and protect, but it's important that it's backed by a child-centred focus. And in amongst all the policy and guidance, the human relationship-based practice element is emphasised, and the voice of the child is heard. A trauma-based response has also been rightly emphasised in recent years, and it's important to consider the impact of how CP processes and the system feels to children, young people and families. If the process is complex and potentially confusing to practitioners, then it will be more so for families we are working with. The emphasis on voice and the right to be heard and listened to rang out clearly in the promise and goes right back to the UNCRC in 1989 and specifically Article 12. The Children's Scotland Act 2020, to just pick one example from this slide, aims to put children and children's views at the heart of decision-making processes to ensure that fair treatment of children and families by Scotland's civil courts is made. This new legislation has again been directly influenced by the UNCRC in Article 12 on the right to maintain contact with parents who have separated, as embodied in Article 9. Okay, so I've spoken a wee bit about child protection practice, the complexity of it, and I think I hinted at the start that, you know, I think a lot of the policy and legislation that's out there is very good, and some of the issue is about how it's implemented in practice, and we know that the GIRFEC refresh told us that some of the practice across Scotland is inconsistent and patchy. So legislation and policy developments are there to guide us and tell us how we should practice and talk about best practice, but we need to continually, increasingly focus on rights-based practice. There's a number of implementation challenges. We know at the moment resources and the economic and financial crisis that's befallen us in the last 12 to 18 months has really been a challenge to local authorities and to all services within Scotland. We know about the importance of leadership in terms of cultural change and making changes to practice, and to make practice consistent, we need that strong leadership and direction. And we need to make sure that we're increasing the awareness of rights and thinking about that in our practice and making sure we're challenging some of the language that's used and some of the cultural shifts that are required to embody the best practice. This slide I just want to put up to kind of emphasise again the cultural shift that's required, the emphasis on participation, which is embodied in the promise, and again UNCRC being at the heart of that, and GIRFEC as well. So in summary, UNCRC has fundamentally shaped child protection practice within Scotland. The landscape is complex and ever evolving. A continued focus on rights is essential to drive improvements. Progress has been made, and new legislation has been brought in the last years that has been directly influenced by UNCRC and has made a positive difference. But the voice of children and young people continues to be critical, and we need to pay close attention to implementation of policy and practice if we are to achieve the aspirations embodied in UNCRC and the legislation that's growing from that. Thank you.